May it please your lordship. Listing of a matter for Wednesday matter. There is an urgency in the writ appeal matter against the single of much over now. May it please your lordships. Lordships, an adjournment request was circulated with regards to item number 6, your lordship. May the matter may come up on the 18th, your lordship.
You are appealing on behalf of?
The petition, your lordship.
Okay, on request made by the. When do you want?
Lordship, on the 18th.
Wednesday. I am appealing for the answer number 1.
MS. You are the standing counsel.
NHA.
At which standing counsel?
Public.
Item 1.
May I please, your lordship?
Yeah.
I beg to appear through VC, my lord. Am I audible, your lordship?
Yes, yes.
Lordships, there's an IA which I had filed. I'm also a respondent in the main writ appeal. My lord, on the last date, notice was issued in the IA. Some of the respondents, the address is not complete in the memo of parties. Particularly if your lordship sees page 2 of my IA, respondent number 5 to respondent number 15.
In respect of respondent number 20, it says it's insufficient address. Respondent number 21, addressee expired. Respondent number 22, addressee left. Then 23 to 36 and 44 to 67. There's no, they have not received.
Well, actually, the writ appeal also notice was issued long time back. So I don't know what the status of service in the writ appeal is.
You have not taken steps on respondents 7 to 17.
No, that's what I was pointing out, your lordship. If your lordship sees 7 onwards, the addresses are not complete. And we are also a respondent who was impleaded in the writ petition. And the appellant is the party who's likely to have these addresses. So my respectful prayer today would be if your lordship will direct the appellant to provide these addresses, then we can take effective steps. Because they were made,
for the appellant.
because these respondents were impleaded in the underlying writ petition, which was filed by the appellant.
Yeah, I'll provide the addresses. Okay. You want the addresses from respondent?
Respondent number 672 15.
And 21 has expired.
21
So
is okay.
substitution will have to come.
My lord, this is an IA, if I may just point out, where I had only sought some modification of the interim order, which was passed when the matter was admitted. My lord, so in the writ appeal, if the service is complete, these respondents will have to appear before your lordship in any case. So I am saying that if in the writ appeal the service is complete, then the appeal can be listed for hearing. Because my prayer in the application is very limited. And it may not affect all the respondents.
In the writ appeal, registered post AD was issued only on 8/6/2025. Is it 2023 or 2020?
Possibly in March 2023, my lord.
It appears to be in
20th of March 2023.
So notice is also not complete in the writ appeal.
17th February 23 notice was issued in the writ appeal.
Yeah, correct. So you furnish the address of the respondent.
Whichever addresses are not complete, they may be furnished and will take steps on our IA. My lord, but in the appeal also, my lord, they have to take steps to complete service, and the appeal can also be thereafter listed for hearing because there's some urgency in the matter.
Okay.
Because in the IA, our grievance is that there was a direction in the impugned judgment of the learned single judge by which encroachers in the retainable area were directed to be evicted by the state. Now, that is a direction which actually is in the interest of the appellant. So there is no reason why that particular direction cannot be implemented today. That will in fact address the grievance of the appellant because the encroachers can be evicted based on the retainable area which is known to the state. And the state also, I'm sure, does not have any objection to that. So if that can be implemented, that will in fact protect the interest of the appellant as well. That is one of the main prayers in my application.
My lord, may I kindly see the operative part of the order in the writ appeal at page 294.
No, we are not getting into it. What we are saying is whether notice is complete or not.
Well, what I have found, my lord, from the submissions of my learned friend appearing for the applicant in the IA. My learned friend has submitted that if the notice has been served in the writ appeal to all the respondents, they are the opposite parties in the IA. And my learned friend is himself submitting that let IA be taken up along with the writ appeal for final disposal along with the writ appeal. So that can be done. In that case, I'm again waiting for, because there is urgency in the matter. So again, waiting for service of notice on the opposite parties in the IA, possible may not be.
Okay,
required.
then in the writ appeal,
My lord.
who are the respondents?
Same respondents, my lord.
Same.
respondent. Respondent 5 to 15.
You are the respondent number in the writ appeal?
Yes, my lord. I was initially not implemented. Subsequently, I was implemented, and there's an order of this honorable
Implemented.
court by which we were implemented.
So anybody appealing for the respondents in the writ appeal?
My lord,
Anybody appearing in the writ appeal? Respondents?
for the respondents.
Yes.
My learned friend with the
For the respondent number 65, 66, and 67.
65. Amended cost title
Amended post lordship.
65, 66, and 67. And how about the others?
I'm appearing for 26. 26, 41. And 65.
Petition of appeal করেছিলেন
Because we petition, we appear there, so along with it, we are able to planning the response.
For all the respondents?
Not all the respondents, because all the respondents have not come. There are a few respondents we have prepared, we have argued before it.
Because you are the respondent 65, 66, and 67, correct? In the writ appeal.
And the IA is at their behest on the.
Yes,
on the-
that is
on behalf
why.
of these- Yes.
So the respondent 65, 66, and 67.
Yes,
In writ
my-
appeal, correct? You filed the IA.
Yes.
And the other respondents? That's what we want to know.
I'm also for 41, 26. 41 and 20.
41 and 26. How about the others?
Lord, in fact, most of the respondents did not even contest the matter before the learned single judge.
Before the writ court.
Actually,
were-
the state responsibility is the sole one, man. The entire responsibility of the states.
That's correct, my lord.
Then we can list it for hearing. Oh,
17 February is the first date on which the appeal was admitted.
And my lord, we were impleaded on 22nd August 2024.
Yeah.
Oh. Service. Oh. Good. Okay. Heard, Mr.
A hook on your lordship for the applicant.
Fuka. Leonard counsel for the applicant India. Also heard Mr. D. Majumdar, Leonard, additional advocate general for the
Respondent number 224.
for the state respondent.
My state.
For the
One.
registry is directed to list the matter before the lowers of court with regard to service of notice on in respect of all the private respondents, in respect of the other respondents. Huh? List after 2 weeks. 2 weeks.
With the service report, man.
No, that will come
My-
with
my-
it. In the writ appeal also,
What-
writ appeal is already admitted.
Yes, madam. Writ appeal is admitted and there was an interim order of status quo, madam.
No, that has been confirmed.
Yeah.
But then it has been listed for hearing.
My lord, I'm requesting for a date, my lord, because there's some urgency, and because if the encroachment also continues, that will also defeat the interest of the appellant as well. And Amakia debater's interest also will be protected, my lord, if the direction which was pointed out, my
After
lord,
vacation, it will be after 2 weeks. Vacation starts from 28.
Yeah.
my lord.
So we'll have it on the immediately after vacation, 17th. Is it all right for you? It's a hearing day.
17th. No, madam, first the report must come before.
Okay, let it be come
Thereafter
on.
the date can be fixed.
My lord, in August, if it can be kept, my lord, for hearing by then
No,
time.
that for the purpose of ascertaining whether.
No, no,
the
for
case is
purpose
complete or
of
not.
ascertaining whether the notice has been served on the private on the other respondents. Let it come on little
15th.
early.
15th.
It come on 16th, is the Wednesday,
Yes.
My lord, my lord.
just on 16th. The counsel for the applicant is also direct to appear before the lowers of the court for taking necessary steps.
Obliged. my lord.
Madam,
In the IA, huh?
I'm appealing from for 1 to 4.
1 to 4, on top D Majumdar, so and so, for the respond 1 to.
Madam, 41, we are clear. I am for 26 and 4.
And Mr.
B. Sharma, 20.
Leonard Counsel appears for the respondent 26 and 40, 41. 41. Okay.
In place of 16, can it be made 17? 17. 1 second.
Will
17.
my lord also consider mentioning one line that where the addresses are not complete, the appellant may provide us the complete addresses. So that will enable us to take steps, my lord.
In the meantime, the Leonard Counsel for the applicant shall also provide the full.
The appellant, counsel for appellant.
No, Leonard Counsel for the appellant. In writ appeal 53 of 2023 shall also provide the correct and proper address to the Leonard Counsel applying for the applicants in the present line.
Deeply obliged. my lord.
Item 2.
Is it?
My lord, I have some urgency in this case, but then my learned friend,
Oh.
please, I am told that he is not keeping very well. So my lord, can I make a prayer Your lordship fix it on next Thursday, my lord.
Is it supposed to come up for orders or admission?
My lord, it should have been for admission, my lord.
Okay. Heard Mr. is that the senior counsel, assisted by Mr.
H. Murad.
So and so for the, you're for the applicant,
I am for the appellant.
for the applicant. Who you are,
I'm for exercise for not to respond number one and
you want an adjournment?
No, you can not.
Okay, on request
Respond number 3, my lord.
respond number three.
made by Mr. R. Gogoi, R. Gogoi, then standing counsel excise department. Just the matter on 19th,
My
19th,
Yeah.
19th. In the admission call.
my learned friend, such a young person, respond number 3. Now, he is saying that he is not keeping well. In such type of fragile health, my lord, I could come, he cannot come. Always, my lord.
Item 3,
In this writ appeal, I file a writ appeal with a delay condemnation petition, which is miss case, my lord, 1460/2025. And you also, can you take up the miss case, my lord? There are 8 respondents, my lord. Regarding 8 respondents, my lord, there is
Manda, you,
no notice has been, my lord, regarding issuance of notice regarding respondent number 9, no notice. Yes, respondent number 8. So, my lord, notice may be indicating that, my lord, I'll take steps.
okay. You are the counsel for the applicant. Shall take steps for service of notice. On the respondent number 8
Wait, my
by registered post ID. Within 1 week,
my lord,
list of the forms.
deeply of
item 9, orders.
My lord, in this case, my lord, I filed a application on behalf of the Guwahati High Court, my lord, Registry. And your lordship kindly see the order, my lord.
Yeah.
Annex A, page 13. There is a discrepancy in, my lord, one reported judgment and one, my lord, uploaded copy, my lord. So then, my lord, matter was taken up. There's an inquiry report submitted, and thereafter, my lord, that order was passed. Your lordship kindly see, my lord, page 19, my lord. Page 19. Page 19, that is the, my lord, order passed on 15/5/2025. And finding that, my lord, page 20, my lord, so and so, private secretary, finding, my lord, page 20, my lord. Appears to have uploaded the judgment, dated so and so, past in so and so, without verifying the same with the original signature and so and so. In that context, my lord, your lordship kindly see the first para of the page 21. In that context, my lord. So, taking into the consideration above the facts and circumstances of the case, we deem it appropriate to direct the registry to initiate a disciplinary proceeding against the Srimati Sunita Das, private secretary so and so, and also direct the copying section, Guwahati High Court, to henceforth, before issuing a certified copy of the judgment and order passed in any case, uploaded the online copy on the judgment and order should be verified with the original signed judgment or order and as available in the case record. So in that process, my lord, it will, my lord, it will harsh to, my lord, your lordship kindly see para 5 of the, my lord, my petition, my lord.
Yeah.
Para 5, my lord.
You want to make this,
Page 8, my lord. Page 8, para 5, my lord.
para 6 is the main thing.
6 also, my lord. So 6 is our suggestion, my lord. If it is then that way, my lord, is modified, my lord, then it will be benefited for all, my lord. Otherwise, it will take, my lord, 1 week. It will be hard work for the, as well as the copying section, all the others also. If, my lord, the verified, second verified, that is, my lord, the private secretary right, then it will be very easy, my lord. So may I pay that, my lord, your lordship kindly, if your lordship modified in that way, then it will be benefited to the all litigant as well as my lord.
For the other side,
No, my lord, it is, I think they don't have any objection because it is offshoot, my lord.
Okay, there's one private respondent. Anybody appearing?
Because without affecting their,
Respondent number one, appellant one,
Yes,
you appearing.
well, only one prayer, my lord. If lordship is taking up page 21, the last page of this interlocutory application, my lord, the last paragraph. The last paragraph, my lord. The certified copy of the original signed judgment available in records be supplied to the learned counsel for the, but this has not been supplied to us. Because the difficulty is that if we again apply for certified copy, again that discrepancy may occur.
Read the last line.
On moving appropriate applications, my lord.
Then you make your
An
application.
yes.
my lord, I'll take care of that.
Okay.
Itu question. So I'll take care of it. No problem. Itu balik amat jangan langsung mana bang.
The private secretary must have some commitment.
Only one item, moving an appropriate application, some confusion which has, whether this means, a fresh application for obtaining a certified copy or any interlocutory application in this appeal itself. If lordship maybe please to clarify that much, my lord.
What clarification is
That is-
required
For
here?
the particular case, I'm in general.
No, my lord, I am on the
Particular
flow of obtaining the certified copy by moving an appropriate application. Now, this appropriate application may mean and include, my lord, whether I need to file an interlocutory application in the appeal
There's
itself
an
or a
appeal,
fresh-
there's an appeal pending.
or a fresh
No,
application for obtaining a certified
Certified
copy.
copy. I think application form of being a certified copy, getting a certified copy.
That I can do at any time, my lord. But
That is always of
this is the order passed by
Make
the
your
Honorable
application,
Court,
there's
my
no
lord.
need.
the application to certified copy, not to modify.
Okay.
He thought that he will file an application before this honorable.
Now,
No.
once you get the correct judgment,
My lord. I will apply, my lord.
you'll have to amend your appeal
Yes, that is a consequence that will
After
necessarily
that,
follow,
yes,
my
sir.
lord.
because you've not taken any grounds. Because the judgment that was given to you was something,
My lord.
some
Absolutely.
paragraphs were missing there.
Yes, my lord, the last few paragraphs were missing.
So
Now,
where the main reasoning was given.
Absolutely,
So
absolutely.
maybe you'll have to challenge those reasons.
Absolutely,
Again, he has to amend this very also,
read
because
appeal.
he has to take grounds. New ground, new ground.
You will pass it in. You pass the order.
Dispose of this case.
Or you want to dispose it?
I dispose of it. Leave it. Fine.
By Mr.
A Burwa.
Council appearing. Also, by Mr. Arthur, which are the standing council. Appearing body. Opposite party number 1. 5,
Yes, my lord.
comma. Appellants, right? And also the. And plus, the. So appearing body. 1.
Yes.
No, no. So
Problem.
page 4. So page 4.
governance standing for the respondents number 1. Also help Ms. Canada's government council appearing for the opposite party number 2. And Mr. B. So can government appearing for respondent number 3, 4, 5, 6, 7, 8, 9. The present application has removed by the applicants bring for a modification of the order of the directions passed by the ordinary bench of this court. While order dated 5/2025 in the coming to the writ appeal being writ appeal number 135/2020. The direction of which modification is sought for. The present order is extracted here in bill. Page 21. The post of the full in. So it is the convention of the applicants that the cell system of issuance. I think the system of that's also a convention of the applicants that for issuance of the certified copy if the method as prescribed by this court by the order dated so and so is to be 15/5/2025 is to be implemented, the same would be a time consuming one and would not benefit either the applicants nor the registry of this court. According to the applicants have suggested the following measures to be put in place. Check. Check and balance in the matter and will have authenticity of the certified copies issued by the copying section of the registry. Also, the measures put in requested to be put in place by the applicant being relevant is quoted here in middle page 9 into these. Also, we have considered the contentions made by the applicant in the and also the raised by Mr. in the amount of the Indian council during the hearing of the present application. Also, on a consideration of the matter, we are considered that the directions of the hearing was by the school, by the court methods of the school, by the order taking 15/5 call for a modification and according the said order is modified and is substituted by the measures recommended by the registry of the school and quoted here above. Also, the registry is directed to issue appropriate notifications in this connection after receiving an approval for the same from the Honorable Chief Justice acting in the
Developed.
also.
Contain. Yes, so we are not indifferent to this.
Also, further it is to be that the modification, the present order is fully will be still not in balance. So I think
Exactly.
we have not will be in direction or initiation of different things against this. So we can thus find and second as guiding.
Right.
While they say what it is,
Developed.
I get this also.
I dispose.
Item 4. Admission stay. Item.
Made.
Yes.
But here we have challenged a part of the Yeah.
Yes.
But in the petition, I challenged the impugn order at the 11/11/2024, by which the private respondent was allowed to hold the charge of vice principal of homeopathic medical college and hospital.
Okay.
And
Your good name?
K.M. Halal.
Heard Mr. K.M. Haller, then the counsel for the appellate. Stop. You have to admit it. Admit. No, notice has to go, isn't it? Mr. D. Upamanian, the standing counsel,
Health Department.
Health Department appears for the respondent,
1, 2, and 3.
1, 2, and
3.
3 also?
Yes.
3, okay. Appellant to take steps for service of office on the respondent number 4 by registered proceeding within 1 week, list after 4 weeks. In the interim, comma, the judgment dated 8/5/2025 passed in writ WBC 6110 of the 2024. Yeah. Insofar as it relates to allowing the respondent number 4 to continue to hold the post of in charge vice principal of SGN Homeopathic Medical College and Hospital, Guwahati, till the post is filled up on regular basis, shall remain suspended.
Much.
But the department is allowed to fill up the post on that maybe.
We however make it clear that the department shall proceed to fill up the post of what post?
Vice principal.
Vice principal of SGN Homeopathic Medical College and Hospital, Guwahati on regular basis.
Much.
Item 5.
I pray that Lord, this matter may be adjourned for a week, my Lord. I will require some, my Lord, more documents, my Lord, regarding a.
Not only documents,
My Lord.
you may have to file an application for condonation of daily oaths. Think about it.
My Lord.
Judgment was of 2022.
My Lord, thereafter review petition.
Review was of 2024.
My Lord,
Correct.
but within the 1 month period from. But. It will have to be.
On request made by
in the-
PG Fukant, learned counsel for the appellant. List after
After 2 weeks, my Lord.
2 weeks. Okay, list after the summer weeks.
Most of them.
Item 10. Admission without stay. Sorry, admission with stay.
My Lord, only on 2 aspects, my Lord, and before the sound of report. A housing loan spread over 300 EMIs with effect from 30th July 2019, which as per my calculation is going to subsist till 2044. If the entire period of EMIs is to be taken into consideration. The petitioner and the co-borrower, who happens to be his deceased father, paid an amount of 9 lakhs, defaulted thereafter, admittedly defaulted, and thereafter there have been attempts to regularize the loan account, and by regularization, what the petitioner understood was to repay the overdue amount. But now what is given to understand is that there is an application by the bank before the district administration, the district magistrate to be precise, under section 14 of the SARFAESI Act, And section 14 is a resort taken by the bank after exercising the options of section 13(2), which is a notice requiring the borrower to repay the entire outstanding loan amount within a period of 60 days. Failing which, it is contemplated in the section 13(2) notice itself that action will be taken under section 13(4). And section 13(4) envisages, my lord, the provisions where, my lord, the power is vested upon the bank to take actions in the nature of taking symbolic possession of the secured assets, physical possession of the secured asset, putting the secured assets to sale, and if the borrower is aggrieved by such action under section 13(4), the act itself provides for, my lord, the scope of appeal or the scope of application under section 17 before the learned debt recovery tribunal. Now, I have been left optionless because of the fact that, as per my instructions on oath, the petitioner has come up to say that he was neither served with section 13(2) notice nor 13(4) notice. And even so far, the knowledge about this order, which is imposed at page 17, this also he has come to know only on going to the bank to discuss about the prospect of regularizing the loan.
So this 13(2) notice was given to you or not?
No, madam. As per my instruction, the petitioner has come up on oath in saying that he never received 13(2) notice. Had he received, he would have had the option of preparing a representation, which the bank would have been required to dispose of as per section.
Where have you stated in your application that
My-
you have not served 13(2)
My-
notice?
My lord, will come to paragraph, it starts from page 9 down below, paragraph number 13. May I just read this paragraph? This is my entire case, my lord. At paragraph 13, starting from page number 9. May I read it, my lord? That the petitioner humbly begs to state that a bare perusal of the impugn order makes it clear that the order was passed pursuant to an application filed by the respondent bank under section 14 of the SARFAESI Act 2002. This is a stage for taking possession of the secured asset by the bank. This stage is preceded by the procedures laid down under section 13 of the SARFAESI Act 2002. To start off with, a notice under section 13(2) of the SARFAESI Act 2002 is required to be served upon the borrower for repayment of the entire outstanding loan amount within
Okay.
60 days from the date of notice. On receipt of such notice under section 13(2), if the borrower
yes.
makes any representation or raises any objection, my lord,
Oh, we can suspend that order. Oh, anybody appearing for the bank?
notice has to go. We inquired yesterday while filing whether they take copy, but I was told that notice has to go and only then.
Okay, they don't have
They
a,
don't have any retainer come.
you take Dusty,
My lord, let me
heard Mr.
teach Chakravarti.
D. Chakravarti, learned counsel for the petition. Issue notice on all the respondents. The petitioner is permitted to take steps for service of notice on the respondents. On all the respondents by Dusty Service. On all the
Yes.
respondents, are they all from Guwahati?
No, my lord, they're Sibsagar, my lord. I'll get it served at Sibsagar. The addresses are of Sibsagar.
Okay. How about one, respondent one, that also same, Sibsagar.
Sibsagar, my lord. So, in fact, the other respondents, my lord, are from Jorhat, my lord. Their regional offices at Jorhat.
No,
And
one is Sibsagar.
One is Sibsagar.
But then respondent one.
One is Sibsagar, my lord.
Respondent one,
My lord, Bank of Baroda. Your
having
lordship-
its registered office at Mandvi,
No,
Baroda.
that is the registered office. Your lordship kindly comes to page number 4.
Oh,
That is the branch I'm talking about. I am concerned with the branch, my lord. Where page number 4, my lord.
on all the respondents by Dusty Service to the registry of this court within 1 week from
Right.
the day. Drafted, the petitioner shall file an affidavit to that effect. When do you want?
My lord, after a week, my lord, within a week, my lord, I'm going to file my affidavit. Thereafter, my lord,
Next Friday
my lord.
is 20 June. Till the next returnable date, no course of steps shall be taken against the petition. Yes, sir, as the petitioner, the counsel for the petition has submitted that no notice under section 13, within bracket 2 of this act, SARFAESI Act 2022, has been served on the petitioner. Oblique 13.4 and of 13.4 of the so-and-so act. It is directed that no courtship steps be taken against the petitioner until the next.
Strictly obliged, strictly obliged. Sincere apology, Lordship. In item number 4, Lordship, the order was passed not to keep the respondent number 4 as vice principal, Lordship. Thereafter, I have informed this order to the department, Lordship. They have stated that the principal is also currently suspended, Lordship. So there is no one to.
You make your own arrangements. You make your own arrangements.
It was meant to be taken up on Monday, Lordship. So that's.
Who was the other counsel?
KM Halloween.
Huh?
KM Halloween. I'll
Call him, just call him then. Who took the order? Item 4. Name 1, 2.
I'll inform.
Just bring him. Call.
Item 7, admission without stay.
This is a public interest case of petition, my lord. In the interest of the students of the GA. Basically, my lord, who are pursuing their education in the research training college Mirza. And as per the NCT Act, it is, my lord, mandatory.
Just a minute. Yes.
As per the NCT Act, my lord, to impart the education in the GA course. It's a very serious allegation. Time.
Yes, one.
My lord, as per the NCT Act, my lord, without having the recognition from the NCT, no, my lord, course of BA can be, my lord, imparted in any institution. My lord. In this case, with the response number 10, their recognition was withdrawn as back as 2021. It is Annexure 1 at page, my lord, 35 by the NCT. And by this, my lord, this page number 39, Lordship will get in point number 5. Now, therefore, the recognition granted to the institution Vice Teachers Training College, Mirza, Post Office Assistant, Kamrup, Assam, for BA courses is hereby withdrawn under the section 17(1) of NCT Act for this academic session 2020 or 22. Well, in spite of this, well, the recognition was withdrawn. The university under which well, the institution was affiliated. Well, as per provision was that once the recognition is withdrawn, well, the affiliation has to be withdrawn immediately. And that was not withdrawn, but instead, well, they are showing a publication of 2 publications consecutively in India 2022 and again in 24. By which they are saying in 34 number, serial number 34, that this institution having the NCT minor recognition. So accordingly, my lord, the course was imparting and students were giving the admission. So now these things has come. When these things was, my petitioner has searching the website of the official website of NCT, that was found. And subsequently, my lord, this news item also published in the student also various media published in the regarding illegally committed by the institution. So my at this case, I am in the interest of the students. So all the things, because the communication was very much like what it. So in spite of all these things, they are continuing these things illegally, my lord. That cannot be. And the Supreme Court also in the case of the section, my lord, this case of my lord, other Shiksha Mahavidyalaya, it is specifically stated. Once the recognition is withdrawn, the affiliation has to be withdrawn, and no course of BA can be imparted in this same institution. If something is done, that course also will not recognize. And no student can come for the recognition. And section 14 and as well as 17(1) NCT. This is mandatory provisions. And moreover, my lord, the Honorable Supreme Court in the case of the section Mahavidyalaya case, my lord, in para number lordship, I can lordship,
My lord, before my
my lord, let me
learned
finish.
friend goes deeper into the merit of the case, I'll be arguing on the my lord, aspect of maintainability locus standi.
No, see, Amanda,
My lord.
Except 37 page, there's nothing about their.
you have the option of filing an FIR.
Now, after my lord, lordship, my lord, before that, my lord, it is I am coming, my lord. Lordship, I have communicated entire allegation. Lordship,
whom?
from, yes, concerned authority, my lord, university including also, from page Annexure 6 onward from 46.
Page?
Page 46. Lot of, my lord, communication to all the authorities. This is.
Okay, fine. But
My
you
lord, this-
file an FIR. File an FIR against this
No,
college.
my lord, FIR, my lord, in the interest of the student, I cannot file the FIR because the concerned student has to come for the filing FIR. But the so far, the my lord, illegally.
Why you can't file the FIR?
My lord, concerned student will file the FIR, my lord. I am coming on the public interest litigation, my lord. In the interest of the student, they are suffering, but because Supreme Court judgment, my lord, it is, I have mentioned and I have given the para, my lord. This is para 33, page, my lord, page 52, lordship. It is very clear. And relevant portion, my lord, in Roman clause 9. It is a contempt as well as, my lord. This is, my lord, Supreme Court has given a clear mandate that we cannot violation of these things.
What my lord is describing is the allegations and the petition reveals that this is a forgery. It's a fake thing, right? So my lord has asked you why a criminal proceeding is not being initiated by.
That to me, my lord, that, but there is,
That-
but the,
Let
so
that
for the,
be taken. Why should we come in a PI?
my lord,
If there is a students and nobody has any grievance, why should you have a grievance?
my lord,
One.
because,
Two, if that is a fraud, it seems to be a fraud. File a FIR.
my lord, so for the, my lord, delegation I brought before the authority or concern already, my lord.
You
This
bought
is-
it or before the all authorities on one day, that is 7/4/25.
Yes, my lord,
And
immediately.
thereafter you have not pursued the matter.
No, my lord, I am, my lord, pursuing these things because, well, there is no such sort of action. That is why I can.
And that's why the next
And-
course of action open to you is institute a criminal proceeding.
And my lord, one thing, my lord, the kindly have a
Because
last,
this is against the society at large.
yes, my last,
This
my
is
lord,
to
the
be all-
paper publication also, my lord, this is the source one of death, my lord.
Huh?
This is last and except it's a paper publication, my lord.
Paper
It is
publication.
widely published, my lord. This is the media also, it is coming in every day.
See,
It's
no.
there, file a criminal.
One time you file a FIR,
Let the
Yeah.
proceeding.
after that, if nothing happens, then you can come. Otherwise, we don't see any reason to entertain this PIL at this stage.
Maybe at the interest of the students, my lord. Because
We can
students
give
are
you,
somebody.
we can give you.
Because my lord, lordship has a look at the judgment of the Supreme Court, my lord. It is very clear, my lord. It is the now student cannot come for the recognition also. That their course is whatever they have obtained, this is a, my lord, gone.
So that
nothing.
particular respondent number 10 is
No,
playing.
not only 10, my lord. It is at the behest of the 9. He is the main person, my lord.
Nine
Who is a holding
9
the
and
post
10.
of the 4.
9 and 10,
Yes, my lord.
they
Because
are playing fraud.
Because, my lord, he is the person, the director of the university, my lord, college development council, he is, my lord, looking after the all the things, who has got the affiliation, whose affiliation is cancelled. So he is the person authority, my lord, behind the all the scene. So he, a proper action has to be taken against this
You
respondent
file
number
an FIR.
9 as well as, my lord, holding the post of the 4, along with the 10. They are the authority, my lord.
We're not
Nothing was,
satisfied.
but everything was
We're not
why I have,
satisfied.
my lord, in para 16 and 17. I have specifically made the, my lord, the malafide national of the respondent number 9. My lord, there is a huge, my lord, transaction of money because of that things that is going on. I specifically mentioned in para 16 and 17. I specifically mentioned, my lord.
So all those things can be taken up in the criminal case.
That is true, my lord. But the
Then-
lordship, my lord, whatever the interest of the students is concerned, my lord, lordship have a right to go, my lord.
That also would be looking into the interest of the students in the criminal case.
My lord, now, my lord, one thing, another. After not only that, even now they are issuing another notification by which this year also they are going to start in the class. I have annexed the document also by notification of the institution of 2017. Kindly have a look, my lord.
That once the FIR is filed, the authorities would take necessary steps in that matter. We don't see any reason.
My lord, but I think, my lord, this is the right case to be agitated before your lordship as a PIL, my lord. So from my understanding is good like that. So there is nothing,
Your
my lord, any,
understanding and our understanding are just a little.
because my lord, lordship has an annex of 5 at page 45, my lord. Lordship, kindly have money. Kindly have, my lord. In spite of all the things, they issue this fresh notification to attend the classes.
So this is.
Even then, I have given to your lordship, well, whatever decision will lordship will take, but my humble submission, that this is a clear case to be taken as a PI, my lord.
Sir,
If it is not taken as a clear,
amount of this, if your statements, we hold it to be true, we hold it to be. Then this is a misrepresentation.
yes, my lord, this is no doubt, my lord.
It's a misrepresentation not to a particular person, but to community at large. What prevents you from filing it?
My lord, one thing, my lord, my prayer, my lord, it is suppose lordship has taken it as a PI, my lord, issuing notice. Lordship can give it a direction because in my own case, my lord, if I file my affair, there will be no taken action against the my lord. I very much well, my lord.
Supreme Court, right from Soren's case, is very clear on that. That if that is an option open, you must exercise that option.
Then, my lord, lordship has given a my lord, observation that they ask whenever I file the affair, my lord, they have to take the from action. My otherwise, they have to be lying, my lord, without any, my lord, I frankly speaking, lordship, now the authorities like that. If I go to that to the police station, then no action will be taken immediately, my lord. I know because the media publication has done it, my lord, more than 5-6 years ago, my lord. Till today, no action has been taken by the authority concerned. Till today, my lord, I know very well. No police action, no university has taken the action against those persons also. 5-6 days has gone. Let him produce the what action they has taken, my lord.
My lord,
I have
the
frankly
petitioner
speaking.
has not come with clean hands, my lord. My lord, there are 4 directors of this Montage Foundation. 2 directors have filed 4 writ petitions before this honorable court. My lord. 4 directors. My lord.
For what?
My lord, for
Different
they are, my lord, one college is there for B.Ed course. My lord. And same, my lord, it is not, my lord, public interest litigation, private interest litigation. It is against that B.Ed course, my lord. And my lord, except page 37, that registration, my lord, certificate. My lord, there is nothing about the institution. My lord.
Oh, okay, then we do one
My
thing.
lord, the locus standi,
If
whether it is public
you-
interest or
you-
private
you
interest,
take
and the
ins-
students will come forward, my lord. The
you
staff
take
will-
instructions
Will.
and come. If you want to file an affidavit, we'll permit you to file an affidavit.
Will.
And after that, if we see that this is not a public interest
No,
litigation,
my lord.
but
Totally
it
private
is,
interest
but it
litigation,
is something
totally
else,
misleading, my lord.
then we'll dismiss with cost.
My lord. No, that will be better option, my lord. No, I have got some, my lord, judgments also in this regard, my lord.
Because filing PIL, the court takes a serious view on this.
My lord, my lord,
When you misrepresent in the PIL,
my lord.
there'll be heavy cost.
My lord, this so far, my lord, allegation
There are
is made by
altogether
this
4
my lord, the
directors.
director. But he is the only person, my lord, he is only looking after this thing. But the other person was not here, my lord, before your lordship.
Why it
Okay,
has been
first-
suppressed
My lord,
in this
the
petition, my lord.
signature was put by the particular one person,
Except
my lord.
page number 37,
My
nothing
lord,
is there.
the motto is here, my lord, I have given the, my lord. My lord. But illegality is illegally that is committed, my lord. No action has been taken by the University of Tirupati.
You also come to the Guwahati High Court rules with regard to PIL. Part 3, Rule 10, F. If the petitioner is an organization, the names and address of its office bearers and the nature of its activities shall also be stated.
My lord, I have given, my lord.
Where?
I have para 5, my lord, I have specifically mentioned that. My lord, para 5, I have in my requisition. This PL.
Four distributions.
It mentions only the director.
There are 4 directors. 2 directors have moved this honorable court with 4 writ petition. I can furnish the writ petition numbers. Everything has been suppressed.
Okay, heard P. Manda, Learned Counsel for the petition. Mr. P.G. Fukan, Learned Standing Counsel, Guwahati University.
Correspondent 1 to 4.
Shall appearing for the respondent.
1 to 3 and 4.
1, 2, 3, and 4 shall receive instructions in the matter. How much time you require?
My lord, within 2 weeks, my lord.
2 weeks, list after 2 weeks. In the meantime, you take, we're not passing any order on this issue. If you want to, Rule 10F.
Otherwise, he will have to
Guwahati High
withdraw.
Court.
Otherwise,
Yeah, rule.
I have not withdrawn, my
My
lord.
lord.
The allegation, whatever
Okay,
they-
fine.
Lord,
My lord, whatever illegality they have committed, that to be, my lord, looking to, my lord.
If there's something behind this BIL, you'll have to pay heavy cost.
6 and 7, my lord, I am appearing.
Mr. I. Alam, Leonard Standing Counsel, NCT, appears for the respondent 6 and 7. Okay.
most of them.
Item 8,
Master plan.
Lordship, in this case, pleadings are complete, Lordship. Matter may be admitted and fixed for hearing, Lordship.
It's not admitted.
No.
Heard the Leonard Counsel appearing for the parties, for all the parties. Admit, list the matter for hearing. When? After?
In August? August.
In the month of August 2025.
Item 11,
Lordship, in this case, we have to file the IA because my friend is pursuing the contempt there, and the case is fixed on 16th. And the case, CAT has asked either you bring some stay order or you comply with the order. The matter relates, Lordship. A departmental proceeding is initiated against the respondent, Lordship, for dereliction, duty and negligence. The charges were, Lordship, that he did not maintain the ledger books, did not maintain the error books, Lordship, by which this matter can also be, Lordship, heard immediately after vacation. Only in the meantime, we may be protected. Otherwise, you have to comply with the order.
Yeah, the pleadings are completed. You can hear also today. You can complete.
Yes, I'm ready to submit on merits also, Lordship. Lordship. Yes, that's why, Lordship.
Because order was because of the nature of the allegations.
Lordship.
Yes.
We now did person.
Because they are pursuing the contempt now.
Sometimes your whatever subject to the outcome.
Yes, subject to.
Lordship may just submit for a few minutes, Lordship. Lordship, can we come to my petition, Lordship? The allegation was that he did not maintain the laser books and did not maintain the error book by which in every year the person who did not produce the passbook for entry of interest, he has to report to the divisional office. Thus, whether that was his duty or not, Lordship. Lordship, can we come to page 112? May read verification of balances.
My lord,
May-
this rule does
thereafter
not
he can
applicable to him. At
There-
the first,
There
what
are-
they have
let me
mentioned,
complete- let me
this
complete-
rule is not maintainable for him.
Let me
He is
complete.
not responsible for this thing. And in the
Okay.
page 64, 65,
Yeah,
67.
the
and
property.
53,
Lordship, may we read, Lordship. 75, sub-rule 1, the receipt of the first book at the head post office and sub post office at least once a year for posting of interest in respect of saving banks, accounts of at extra departmental sub office and branch office is necessary. In respect of first books which are not received for entry of interest in 30th June at these offices, the following procedure will be followed for collecting them from the depositors. The extra departmental sub and branch postmaster should collect the passbook from the savings account which are not presented for transaction by 30th June every year and send them to the head office accounts which list in duplicate for entry interest in July at the list. So, Lordship, this trust and responsibility upon he is the sub postmaster of the sub office, Lordship. He has to call from the branch office, Lordship, after him. So, Lordship, because of this, all this, there was one Mr. Rajbangshi has embezzled more than 5 lakhs.
Where's the order?
Department, Lordship, CAT's order, Lordship.
Yes.
Lordship.
95.
Yes, Lordship, may come to page 108. That is the finding given, Lordship. Paragraph 9. The CAT basically gave the finding that there was a delay of 8 years. And the second is we could not prove there is a nexus or collusion between the petitioner and the person who was embezzled. Now, allegation was not that he was conspired, he acted with him or he get any benefit. Allegation was there is a negligence and dereliction of duty. That differentiation that was failed to understand. And about the amount, Lordship, why it was imposed, not only he was punished, Lordship, other persons has also been punished, Lordship. I have the list, Lordship. May kindly look into this. Lordship will see the person who is responsible or this is Madan Chandra Rajbangshi. He has been removed. And who has been held for recovery, Lordship? Devendra Sohria. This is the respondent number 1. This is the respondent. Next page, Lordship will find, Lordship, Juriti Devi from her 50,000 lordship. One James Basumatari from him 87,000. So he alone has not been.
He has been dismissed.
He has been dismissed, lordship.
Oh,
He will be forfeited from all the benefits, lordship.
Recovery why it was not paid from? Why the recovery was taken from? But if he is the main culprit, he
Lordship,
he is the-
dismissed it. Why do recovery from?
Perhaps he has been forfeited from his, I can take the
no,
instruction.
no.
lordship.
How
I can
about
take the instruction,
Rubul
Lord.
Goswami?
Rubul Goswami has been censured, lordship.
Biplab Das,
All their inspectors, supervisor. from the PM,
supervisors.
Madhav Ratham's.
You comply?
Oh, comply. Subject to outcome, lordship.
Hurt Mr. B. Chakrabarti, Leonard CGC for the petitions. Stop. Also hurt Mr.
DN Sharma.
DN Sharma, Leonard Counsel for the respondent. Has it been admitted?
No, no,
Any other respondents?
no, only sole respondent.
Admit. List the matter for hearing after
This may be in the month of August, lordship.
in the month of August 2025. Stop. Any steps taken by the petitioners pursuant to the
Order dated 10/1/2024.
you will just say shall be subject to the. Where's that page 85? Tribunal order
Lordship. Page 95, lordship.
95. Any steps taken by the petitioners pursuant to the order dated 10th January
January.
2024,
OA
passed by the Central Administrative Tribunal Guwahati Bench, OA number 040/0019/2019 shall be subject to the outcome of this.
Item 4.
Well, one problem is arising. The principal of this University College, he was suspended on 5/5/25. The order was passed, setting aside the insides seat order. The which was impugned the writ petition on 8/5. So as on date, there is the principal as well as the vice principal if this particular party state. Some arrangement, it's allowed to continue. Instead of 4 months, lordship can make it 3 months, or let the government do something, some direction to them, some indication.
What order was passed?
Order was passed, Lord, that the impugn order was,
Well, the last para of the impugn order,
Did we
page 111,
admit it?
whereby the private respondent was allowed to
Paul
continue.
Nirpunda?
May I keep my question?
Yes, sir. Respondent number 4 is continuing.
Yes, that is under put to
Is-
challenge.
continue,
No, that's right. Still now is continuing.
continuous suspension.
Vice principal. Principal is under suspension.
Under suspension on 5/5. So prior to the disposal, some inadvertently, that could not be brought to the knowledge of the law court at the time.
That was not the
Others
subject
on
matter of
the
challenge,
stage
Lord. That was not the subject matter. And till now, nobody is holding the charge of principal. Although
I think
What I would play is, lordship will grant.
did we admit this case?
yes, Lord, this case is admitted and that part is stayed.
Okay.
That part is me.
Lordship will grant the 7 days time to the government to post someone. Till that time, let the continue. Otherwise, we will be in trouble. 1 day.
Again, my lord, then again, you will, after setting aside that order, on the basis of which order he was holding the site.
Okay, let it come on tomorrow's the Saturday. Monday will take up.
Lordship.
Huh?
Well,
In the meantime, you get proper
Yes,
instructions
yes.
and take steps so that on Monday we can.
Lordship.
Okay, heard Mr. K.M. Halloi, learned counsel for the petitioner, for the appellant. On request made by B. Gogoi, learned standing counsel health department, or you are the additional AG,
Lordship, let me record it.
additional AG,
Yes.
learned additional AG assigned. Shall list the matter on Monday's 16th. That earlier, okay, you tell him to cancel it, huh?
Till then, that part.
On Monday, it will be.
Monday we're taking up. He wants to get some instructions. Instructions he has got, but then for the
Yes.
alternative
How it will
arrangement,
be
how,
arranged by the
how,
alternative.
that you take. We have made our mind clear
Yes.
that respondent 4 cannot be allowed.
Much.